The opening moments reveal a judge who already has a working map of the dispute before anyone begins arguing. That changes the entire hearing. Instead of letting the parties control the pace, the court immediately narrows the conflict into a handful of financial questions that actually matter. That approach limits emotional detours and forces each side to justify specific requests instead of turning the hearing into a general complaint session.
Blanca Carrillo Zayas, present?
Present.
Okay. Can you state your name?
Blanca Carrillo Zayas.
Okay, thank you, ma'am. And you don't need an interpreter?
No, I'm fine, thank you.
Okay. I just wanted to make sure. And Ms. Bastian, you and your client are here?
Yes, Your Honor.
All right. So I'll hear from the parties. Again, there was a lot of stuff filed, kind of late, but I got the gist of where everything is going. So there's the issue of the car, there's the issue of maintenance, and there's the issue of the mortgage. And then a bunch of little things.
Correct.
In a nutshell. All right. So I'll hear from the parties. Who wants to go first?
I will, Your Honor.
Okay.
On the issue of spousal support, I think her declarations kind of raised some issues on their own. She's arguing that she needs spousal support because she cannot work. She has to be available for the daughter. At what point in time there was allegations of carpal tunnel that may impact her ability to work. But in her declaration, she's talking about all these home improvement projects she's doing. She's remodeling the kitchen, trimming trees, doing gardening. So there's no reason why she cannot return to work. Also, she voluntarily terminated her TANF benefits. I don't know why she would have done that other than she's hoping to receive more spousal support by terminating those cash benefits. I also would like to point out...
Wasn't the child support more than the TANF?
Well, she was getting both, I believe.
You can't.
Okay.
Well, I shouldn't say you can't. I don't know. I never know anymore because sometimes they do some of that stuff. It used to be that you gave up. You either had the TANF or the child support. And so if the child support was more than the TANF, then you'd give up the TANF. But
Your Honor.
the TANF. Is that Miss Maggard?
Yes, Your Honor.
Okay, she'll know. She's the state's attorney for support enforcement.
I actually have a notice of appearance in this case as well.
Okay.
So when the child support order is more than the TANF amount, the TANF has a $50 pass-through, it's called. So they will receive $50 of the child support amount and the TANF grant. So she terminated the TANF grant so that she can receive the child support. The TANF was in lieu of the child support. So it's nothing nefarious that she did.
Okay. No,
it's just the TANF was in place before the child support could be set.
yeah, that's what I thought. I just wanted to make sure because the child support is quite a bit more than the TANF grant.
Yes.
So,
correct.
okay. Go ahead and continue, Ms. Bat. I just wanted to make sure when
Yes, thank
that
you
you
for
can't
clarifying.
get both.
And then the other thing I wanted to address too, in her financial declaration, as a lot of her expenses, she's claiming things that she's not paying for. She's got the automobile loan that my client's been paying for, the lot rent that my client's been paying for, $800 a month for groceries for 2 people, with $250 a month for eating out. My client is back to work. He's making good money, but at this point, he's supporting 3 households. He has his house. It's not a house. It's a room in Boise that he's renting. He has his apartment that he's covering here to continue to be able to visit with his daughter, and he's continuing to cover all the expenses of the home. He's upside down. He doesn't have a bunch of extra money to be giving to her for spousal support when she's capable of employment.
Okay. Ma'am,
Yes, sir.
anything you want to let me know? This is your chance to state your case on why I should do what you want me to do.
Yeah, thank you for giving me the chance. Yeah, it's true. Right now, I don't pay the rent for our mobile home, but before the person, the lawyer, he's write the information that I write. If I pay for myself, I need the money for pay the rent. I know he paid right now everything, the house. So that was, I am not the liar. I say the truth. So only I'm write my financial if I pay by myself.
Okay. In other words, so you're not wanting maintenance if he continues to make the payments on the vehicle and the lot rent and those things? Okay.
Yes.
Ms. Bastian, as far as that goes, I was trying to look through the order. So what is he going to continue to pay those other bills and just no maintenance, and he's fine with that for a period of time, or what? Or I'm trying to figure out, what is it that because if you make payments on things, that's the same as maintenance in essence. I mean, I'll work for, free if I get to live in a house in Hawaii and get a share of Berkshire Hathaway stock, a year. I mean, but
So in the interim, I think he's okay with continuing to cover the expenses associated with the home. He doesn't want to be paying her spousal support on top of that. The end goal is he would like the home sold, and then if she's going to retain the RAV4, he would like her to take over those payments.
But in the meantime, for at least, the next 4, 5, 6 months while you guys figure out if you're going to reach some sort of an agreement.
The discussion about maintenance becomes less about dollars and more about transition. The judge repeatedly signals that temporary support should not become permanent dependence, rather than treating employment as an immediate requirement or an indefinite possibility. The court adopts a middle position that acknowledges real-world hiring delays while expecting measurable effort.
He's fine continuing to pay the household bills, and then mom wouldn't. Now, ma'am, you're going to have to start looking for the old adage, you can't turn a battleship on a dime. You can't just go out and immediately snap your fingers and you've got a job. I think counsel knows that, if not her client, and the court knows that. But at the same time, you have to start turning at some point. So, you're going to have to look at getting a job, inquiring and starting to deal with the resume and whatnot, or, because some of that's going to end up going away. Now at trial or an agreement, there might be spousal maintenance paid for a period of time or something, but I just want to let you know that. So.
Sorry, I interrupt. I already sent a couple applications.
Okay.
So yeah, I'm looking. I'm not only waiting for the money. I'm looking for the job.
All right. Then as far as the maintenance goes, for at least the next, 4 to 6 months, Dad's got to continue to pay. Well, until further order of the court, he's got to pay the bills. And there won't be any maintenance. And you're kind of both on notice. If you want to change that, you need to bring a motion. And if you get things resolved, and ma'am, it sounds like you're looking for jobs, so we're going to do that. All right. As to the car, I saw the materials. Tell me what you want me to know.
It's just the same thing. Again, in her declaration, she's saying the car is not mechanically sound because it had a flat tire one time, while also saying it was safe for him to drive it everywhere. Driving from Moses Lake to Wenatchee or Quincy is substantially different than driving from Moses Lake to Boise. Again, it's that commute that's scary for him in a smaller vehicle. There's nothing wrong with the Toyota Corolla. It's a smaller vehicle that's a long drive, and it is a hybrid, so he would be saving on fuel expenses. And he's been maintaining the payments. He's been covering the insurance on it. So again, he's covering the bills. He should be entitled to drive it. There's no reason why she can't drive the Corolla. She's not working. Their daughter is in school in Moses Lake and rides the bus. And in the event that she does need to drive the daughter around, there's absolutely nothing wrong with that car. And it's paid for.
Ma'am?
Yes. So the small car, Toyota car, is not good for us. I'm had the car for 2 weeks before May 1st, and I am scared driving to the highway 90. So for me and for my daughter, it's more better and safe. We had the RAV4. It's more safe for us. Right now, this Monday is the last day of school. But doesn't matter. She's in the school and the weekend or when she asked me, Mommy, do you have plan for us? Do you have plan for us? So we need why we need to stay in the only Moses Lake? It's much better if she go to outside a different city. She's busy for something else, not only the Moses Lake. That's why I asked for the RAV4. For safe for us and not only for it's my good car for me. No, I'm thinking more in my daughter.
Okay. All right. This is what the court's going to do on the car. I'd like to do what Solomon did and cut it in half, but I can't. That makes it no good for anyone. But I'm going to kind of do that in a way. For right now, Mom has the car right now. I'm going to keep the car with her right now during the summer. The drive down there's no winter, there's no issues with snow, there's nothing like that. That also gives the parties probably 4 or 5 months to see if you can reach, are you going to get this resolved or not? Are you going to have to go to trial, get to mediation? The court, I'm not saying I change it. It can potentially get revisited as we get into the winter months. But at some point, it's going to have, there's only one of the cars and you're going to have to figure that out. She has it. The daughter's there. It's in the summer. There's no issue with, you said it's road worthy. It's just, not quite as handy in the winter, not quite as stable in your declarations, going through windy snow roads and whatnot. But I'm going to kick it to then. But hopefully you guys can get to mediation and see if you can reach some resolution at one point or another. Yeah, there's going to be 2 cars and they're going to get separated. So you got to figure out what's going to happen with the house. So, all right. Anything else the court needs to rule on?
No, that's it, Your Honor.
Okay. All right. Thanks.
Thank you.
The court's solution reveals an important judicial habit of postponing irreversible decisions when circumstances are expected to change naturally. Instead of forcing a permanent answer during the summer, the judge leaves room for seasonal realities, mediation, and possible settlement discussions. That flexibility lowers the immediate conflict without preventing future adjustments. It also encourages both parties to solve the problem themselves rather than relying on repeated court intervention. Judges generally prefer negotiated solutions because they tend to last longer than imposed ones. By acknowledging that winter driving may alter the analysis later, the ruling stays practical instead of rigid. The message is simple. Temporary orders should preserve stability while leaving enough flexibility for better-informed decisions as the case develops. The closing commentary highlights why financial responsibility often becomes the emotional center of divorce litigation. Public reactions frequently focus less on technical legal standards and more on whether the overall arrangement feels balanced. When one party appears to carry nearly every expense, viewers naturally interpret the dispute through the lens of fairness instead of statutory requirements. That difference explains why these hearings generate strong opinions even when the court follows established legal principles. Temporary orders are designed to prevent immediate hardship, not necessarily to create equal satisfaction. The emotional disconnect between legal fairness and perceived fairness is common in family court, especially when financial obligations continue long after the relationship itself has ended. The lasting takeaway from this hearing is not who won a particular motion, but how the judge gradually redirected the case away from competing demands and toward future responsibility. Every major ruling carried an expectation that today's temporary arrangements cannot continue forever without progress from both sides. Employment efforts, mediation, property decisions, and financial restructuring all become benchmarks for whatever hearing comes next. That forward-looking approach reduces the chance that interim orders become permanent habits. Family court is rarely about delivering complete victories. It is about managing instability while encouraging both parties to move toward financial independence and practical solutions. In the long run, judges often reward consistent action more than persuasive arguments, and this hearing quietly reinforces exactly that principle.